upheld Shayara Bano's case was vital. Not only for her immediate claims out, also gave an opportunity to classify the personal law's constitutional status facts of Shayara Bano versus Union of India. The Supreme Court, through a 5-judge bench, held that this practice was unconstitutional on August 22, 2017 in a 3.2 majority. Shayara Bano gets married with Rizwan Ahmed for 15 years. She was divorced by him through instantaneous triple talaq, talaq ibidat, in 2016. She then filed a writ petition on SC on the ground that because they are violating Articles 14, 15, 21, 25 of the Constitution, the following 3 practices should be held unconstitutional: talaq bidat, polygamy, multiple wives. Nikah halal. Shayara Bano's marriage with Rizwan Ahmed was for 15 years. She was one of those women who were survivors of domestic violence and dowry harassment. In 2016, she had been unilaterally divorced through instantaneous triple talaq. A writ petition was then filed by her before the Supreme Court. The petition stated a declaration that the practices of instant triple talaq, polygamy, and nikah halala in Muslim personal law were illegal, unconstitutional, and in violation of several fundamental rights, i.e. Articles 14, equality before law; 15, non-discrimination; 21, right to life with dignity; and 25, right to freedom of conscience and religion. Of the Indian Constitution, the Union of India, as well as the women's rights organizations like the Babak Collective and the Bharatiya Muslim Mahila Andolan (BMMA), also supported Ms. Bano's plea that these practices should be held unconstitutional. They even urged the court to declare that personal law was subject to fundamental rights. The All India Muslim Personal Law Board (AIMPLB) has argued that uncodified Muslim personal law is not subject to constitutional judicial review, and that the court did not have jurisdiction to entertain a constitutional challenge to Muslim personal law, as these are essential practices of the Islamic religion and are protected under Article 25 of the Constitution. On 16 February 2017, Shayara Bano, the Union of India, various women's rights bodies, and the All India Muslim Personal Law Board (AIMPLB) were asked by the court to introduce written submissions on the problems and issues of talaq bidat, nikah halala, and polygamy. Nikah halala, also termed as tahlil marriage, in which a woman through triple talaq was divorced, married another man. Submissions for the above said grounds like talaq bidat, polygamy, and nikah halala from Shayara Bano, Union of India, various bodies supporting women's rights, and AIMPLB, All India Muslim Personal Law Board. On 16 Feb 2017, Union of India and organizations specifically for women's rights like Babak Collective and Bharatiya Muslim Mahila Andolan (BMMA) gave support on the ground that these practices are unconstitutional to Ms. Bano's plea. But AIMPLB made an argument statement stating that, through Art 25 of the Constitution, it is protected that these are some of the essential features of the Islamic religion, and uncodified Muslim personal law is not subjected to the concept of constitutional judicial review under Article 13(2). On 30 March 2017, the Supreme Court formed a 5-judge constitutional bench and accepted Shayara Bano's petition. Then on 22 August 2017, by a 3.2 majority, the 5-judge constitutional bench held that the instantaneous practice of triple talaq is unconstitutional. Issues in Shayara Bano versus Union of India, 2017, 9 SCC 1. Whether the practice of talaq bidat, specifically mentioning whether the practice of instantaneous triple talaq violate any fundamental rights of the Constitution, whether triple talaq protected under Act 25 of the Constitution. Does Shariat Act give triple talaq applicability? Contentions. Arguments supporting Shayara Bano. Petitioner, Mr. Amit Chanda, made an advent into the argument by arguing that Muslim personal law doesn't recognize a form of divorce called triple talaq, and also made a statement like the unilateral form of divorce and triple talaq had brought no Quranic sanctioned divorce under Muslim law is in need of 2 concepts called reasonable cause and preceded attempt of reconciliation. He also argued because it is violating Article 14 and Article 15 of the Constitution, it should be struck down. He gave a solution to the alternative form of divorce where, irrespective of gender, the entire Muslim community will get divorced, which is known as the
Dissolution of Muslim Marriage Act 1939. Argument supporting Shayara Bano by Mr.
Salman Khurshid. He made an advent into the argument by saying that under Quran, after reconciliation attempts failed, and with reasonable cause,